The case itself is an interesting case and raises a bunch of interesting questions and legal issues. I'm going to be focusing, since I'm a law professor, on these legal topics. So to start off with, what exactly does the case do? Because there's a great deal of information that's being circulated, some of which is accurate and some of which is less accurate. The California Supreme Court, in a 4-3 divided decision, held that under the California Constitution, gays and lesbians, because they have been subjected to certain types of harmful treatment, should be considered a protected class under the state constitution. This is a legal finding, which means that they get a certain level of protection, that a certain level of judicial scrutiny is given to laws that would disadvantage gays or lesbians, and as a result, that these laws have to be scrutinized by the court to see whether or not they pass that. It's a complicated constitutional test, but the nutshell version is that the government should have a very good reason for doing what it's doing and not have an easier way to reach the same result without having whatever harms go on at the same time. What the court found is that differential treatment impinges on the same-sex couple's fundamental interest in having their family relationship accorded the same respect and dignity enjoyed by an opposite-sex couple. And because of that, and because there was, as the court found, no, we'll get to in a second, no harms to opposite-sex couple relationships by allowing same-sex relationships, as a result, the court invalidated statutory differences which allowed opposite-sex couples to marry while not allowing same-sex couples to marry. Now, as a bit of background, though, California already had the most extensive domestic partnership laws in the country. And so in California, prior to this decision, in fact, same-sex couples could register as registered domestic partners and receive under state law all of the same benefits that they would receive if they were legally married as husband and wife. This domestic partnership relationship is in a lot of ways very similar to a marriage relationship. From a legal perspective, you can get a cancellation of domestic partnership, which is like a divorce. You can't have a domestic partnership with more than one person at a time. It was essentially a very marriage-like form, but it didn't have the word marriage on it. So this was the status of California law. And so what the Supreme Court decision did was it extended this and extended the right of marriage itself, not merely domestic partnership, to same-sex couples. This has, of course, resulted in a firestorm of back and forth of news stories, of other things, and I've gotten a bunch of emails from my ward, from family members and so on, making specific legal claims, and so I'd like to talk about some of these particular specific legal claims. One legal claim, which has been made a lot by board members, by others, that you see it in the media, is that this decision, the in remarriage case decision, will mean that churches will have to start marrying same-sex couples even if they don't want to, even if there's something in their doctrine that goes against it. What you hear, and you may be getting emails from your ward members about this, we have to stop this because otherwise the church will be forced to marry same-sex couples in the temple. And that claim is made a lot. I've seen that claim made in emails that I've received. I've pushed back because it's a claim that's incorrect as a matter of law. And so let's talk a little bit about why. Will the case result in forced gay temple marriages? No, it won't. And I think if it would, that would be potentially a legitimate reason for concern. I mean, I can see legitimate reasons why we might say we don't want the church being forced to do things that cut against church doctrine. However, that claim is incorrect. This is straight out of the in remarriage cases decision. This is the decision which everybody is freaked out about. Straight out of the decision. No religion will be required to change its religious policies or practices with regard to same-sex couples. No religious officiant will be required to solemnize a marriage in contravention of his or her religious beliefs. California's Constitution, Article 1, Section 4, parentheses. In other words, the California Supreme Court, at the same time as saying that same-sex couples have a right to marry under the state constitution, explicitly say that the state constitution says no religious officiant has to officiate in such marriages. No religious institution has to begin doing such marriages. And when you think about it, that makes a lot of sense. the church isn't required to open the temple doors to everybody who's legally allowed to marry. Jehovah's Witnesses are allowed to marry. Do we have Jehovah's Witnesses marrying in the temple? No, we don't. Muslims allowed to marry. Everybody under the sun is allowed to marry, but very few of these people are allowed to marry in the temple. That's because what we're talking about is a right to marry under the civil law, right to go to the justice of the peace, or for that matter to a religious organization that does want to marry you. But this is not going to result in this, what is often being alleged, this scenario of the church being forced to have same-sex couples being married in the temple. So when you hear that claim being circulated in your ward, you can say, no, actually there's language straight out of the case that goes exactly against that. Now, one thing which people have said when I've pointed that, and smart people have said when I've pointed that out, is they've said, well, what if the court changes its mind? And, well, the court could, in the future, issue a different ruling. I mean, there's nothing, I can't predict the future. I can't say what the California Supreme Court will or won't do. This part of the in remarriage case's decision seems very unlikely to be changed because one thing you learn in law school is you look for the holding of a case, the central statement of what the case stands for. This is linked directly to the holding of the case. Just before the court says gay couples should have the right to marry, they say this is because we don't have these countervening factors. And one of the countervening factors that we don't have is that this isn't going to impinge on religious liberty. And if it was going to impinge on religious liberty, they would have to do separate analysis and see whether they still got to the same conclusion. So this couldn't be changed without rewriting the entire decision. Now, I can't guarantee that that'll never happen, but it seems like a very unlikely thing to happen, at least in the near future. And in the far future, who knows? We can't predict what courts will do, but it seems because it's so directly tied to the court's ruling, to the holding, that this is not something which is going to change. So when your ward members tell you in worried tones that this might happen, you can say, no, under the decision as is, it's not going to happen, and it's because this is so directly tied to the court's central holding, it's unlikely to ever happen in any regime where in remarriage cases hold any legal significance at all. Another question which I've gotten from curious souls of different sorts is, well, what about polygamy? If the California Supreme Court said gay marriage is allowable, what about polygamy? There's a footnote in the case which says, by the way, this doesn't apply to polygamy. So I don't know, usually the first thing I say is I get my scariest look on and I say, only gay polygamy. But but actually there's a footnote in the case which says no polygamy under this case itself. That footnote is not directly tied to the court's holding, I think, and so it's not outside the realm of possibility that that could be changed in a future decision, but at least under the decision as written right now, no, this does not extend to polygamy. You can't walk in with wife or husband number 3 or 4 and say, in remarriage case, right to marry, because the California Supreme Court has said no on that particular issue. From here we get some interesting questions. What does this change? As we've mentioned, California already had the best domestic partnership laws in the country, very strong protections under state law. Under federal law, even if you're a domestic partner in California, and now if you're married in California, a same-sex couple doesn't receive federal benefits. And so you have various federal homophobic Defense of Marriage Acts, and so on, which say that if a same-sex couple is married in California, they still don't get the Social Security benefits, the other federal benefits, which they also wouldn't have received with a domestic partnership. And also, states are not required to extend full faith and credit under the full faith and credit clause to same-sex marriages, again, under federal law as it stands now. And so as a result, this doesn't change a lot. I mean, if you look at it, prior to in remarriage cases, same-sex couples could enter into domestic partnerships in California, could get all rights under state law, didn't get any rights under federal law, and didn't have other states have to recognize this. And now same-sex couples can marry, can get all of the rights under state law, don't get any of the rights under federal law, and other states don't have to recognize it. So other than the label, the legal status has not really changed significantly. I mean, and of course, for my gay and lesbian friends, this is a big deal on a psychic level, on an emotional level. It's very important to have their relationships recognized as marriages, but on a purely legal level, there has not been a significant change in the way that same-sex couples are treated in California under the law. If you are a registered domestic partner prior to in remarriage cases, or if you are a married couple after in remarriage cases, you have essentially the same bundle of legal rights under California law, under federal law. A couple of interesting wrinkles come up, and I get additional questions from these helpful folks in my ward who are very interested in Proposition 8. And a question that I get is, what about taxes? And does this mean that the church is going to lose its tax-exempt status? And people are very worried about this. The short answer is almost certainly not, but potentially. The major case under federal tax law is Bob Jones versus United States. A charitable organization can lose tax exemption if they are if they have to serve a public purpose and not be contrary to established public policy. They must be in harmony with public interest, and the institution's purpose must not be so at odds with community conscience as to undermine public benefit. So that's the language out of Bob Jones. This was used by the IRS to actually talk to Bob Jones University and to take away their tax break because they were prohibiting interracial dating, and then there was this litigation back and forth. It seems like it could be theoretically possible under Bob Jones University for a court to find that the church's stance completely flies against the community conscience. That's a pretty tough standard to meet, though, and it seems that it would be unlikely for a court to do that. In any case, I don't think, my sense is that it would be unlikely for the IRS to even make that sort of bring that action to begin with. The IRS is a relatively conservative, not politically conservative, but just jurisprudentially conservative federal agency. They don't do crazy things in one direction or the other. They pretty much stick to the rule book as it's written, and so it seems extremely unlikely that the IRS would try to bring some sort of action to take away the church's tax exemption because of the church's views on same-sex marriage. If the IRS were to do so, they would have to show that the church was not in harmony with public interest and was completely at odds with the community conscience in a way that undermined any public benefit that they were giving as a charitable institution. People ask the tax questions because, in part, you get these email horror stories circulated about a Methodist church losing their tax, and usually this is all you'll hear in the story. There was a Methodist church who lost their tax break because they refused to marry a gay couple. Ooh. Actually, it turns out that that's a complicated story, and it involves a couple of things. It involves a detailed, and I'm not a New Jersey tax law expert, but I had to look up some things on this, and I think I've got it right. If anybody's a New Jersey tax law expert, feel free to weigh in. This was a non-federal case. This is a state case in New Jersey based on a special exemption for not the church, not the normal church religious institutions exemption, but a special property tax exemption for entities that were fully open to the public. And so when the Methodist Church in New Jersey didn't allow lesbian couples to marry, no, you can't marry in New Jersey, didn't allow lesbian couples to perform a commitment ceremony in their pavilion, they lost a tax break which was about $200 in state property taxes for this particular pavilion. A couple of things to note there. This was not a same-sex marriage case. New Jersey is not a same-sex marriage state. This was a commitment ceremony that this couple was trying to, wanting to schedule there. This is just a provision of New Jersey property tax wrinkles in the New Jersey Code. You can't take any lessons out of this, like, oh no, if the court doesn't like same-sex marriage, we're going to lose everything as far as tax exemptions go. Temples aren't open to the public to begin with. This was a pavilion which was fully open to the public, and then the Methodist Church said, sorry, except for the lesbians, which caused them to lose their property tax break. We don't have anything like that in the church, and we're not asking, that I'm aware of, for property tax breaks. And again, this is not a gay marriage case because it's in New Jersey, which is not a gay marriage state to begin with. So it's incredibly limited, and if and when you see it circulated as a horror story, you can say exactly this to point out that no, this doesn't mean that the church is going to lose its tax breaks. A couple of other questions that I get. There's one wrinkle. How am I doing time-wise? Okay. A couple of other interesting legal questions. Is the proposed constitutional amendment in California, the Proposition 8, is it itself legal? There's been some interesting litigation on that because you can make, the nutshell version, you can make small changes to the Constitution by ballot amendment, but you have to do big changes by constitutional convention. The California Supreme Court, there was litigation brought on this, and the California Supreme Court declined to hear the case. So for the moment, this is legal going forward. This is not apparently a big enough change that there would have to be a constitutional convention called or other procedural measures taken. Is the church legally allowed to bring volunteers in to do things, to organize opposition against same-sex marriage and in favor of the proposed proposition? Generally, yes. Election laws limit charitable organizations in certain ways. You can't specify a certain candidate. You can't say vote for Joe. But as far as legal issues go, charitable organizations have a lot of ability to weigh in on particular issues, and that this appears to be pretty well within the issue side. Nadine might disagree with me, but I think this appears pretty well within the issue side. This is something which the church is weighing in on as an issue rather than an individual candidate, and so that's probably within the church's role legally as a charitable organization. People say, does this violate church and state? The government is the one that's not allowed to mess with your freedom of religion. So this is not really a church and state problem from a legal perspective. It may be from a moral perspective or an ethical perspective. And so you can look at people, founding fathers who are writing and saying churches should not get involved in politics because this dirties the hands of religious organizations, essentially. Those sorts of arguments carry all sorts of potential validity, but as far as a legal claim that the church should not be doing this as a matter of law, that's a claim which I don't think stands up. One other question which I get a lot, and this is the question that nobody actually knows the answer to. What happens if the amendment passes? What happens to the thousands of same-sex couples who have been married? Does this apply retroactively? Does this annul their marriage? Are they grandfathered in or grandmothered in? And the answer to that one, as far as I can tell, and I've talked to a half dozen law professors on it, nobody knows. There's the potential that this could retroactively nullify marriages. On the other hand, there's the potential that it couldn't, and it would be a case of first impression. We'll see what the court would do with it. The amendment won't have a lot of legal effect, whether it passes, whether it doesn't. I mean, if it passes, then again, you lose the marriage label, but you keep the domestic partnership, which is essentially the same from a matter of law, though there's a little bit of a wrinkle there because so many of the clowns who are on the protectmarriage.com website are organizations that have fought against domestic partnership protection and which have said in their own statements on their website that one reason to pass this amendment is so that we can try to roll back those dastardly domestic partnership protections too. So on the face of it, this amendment wouldn't roll back domestic partnership protections, but it would seem to be as intended as a possible springboard to roll back domestic partnership protections as well. That's not a complete list of legal issues, but I think those are some of the main legal issues that come up in the case. Thank you.